He was 72 years old. He had been getting behind the wheel since the age of 16. He had never once been involved in an accident. He had never once received a citation. He carried a spotless driving record, a current license in his pocket, and absolutely no reason in the world to think anything was off. And then one morning, he walked out to his mailbox and pulled out a letter from the DMV, a letter informing him that his name had been entered into a federal driver monitoring system, a letter telling him his license was currently under review, a letter that gave him a cutoff date, August 31st. If he failed to respond by that date, his driving privileges would be suspended. Not because he had broken a single traffic law, not because he had been in an accident, not because he had done a single thing wrong while operating a vehicle, but because his name had landed inside a system he had never once heard of. And he had absolutely no clue how it ended up there. That is the reality facing 44 million American seniors at this very moment. 44 million. That surpasses the entire population of California. That exceeds the entire population of Texas. That accounts for nearly 1 out of every 5 drivers currently on the road. And if you are over 70, or if you have a parent, a grandparent, or a neighbor who is, you need to understand what is unfolding right now, because a federal driver monitoring system has been quietly launched across the United States, and it is now keeping tabs on millions of older drivers. Your name could already be inside this system, and if it is, you are working against a deadline. August is approaching fast, and if you do not verify your name before August comes to a close, you could lose your driving privileges without ever receiving a single advance warning. This is not a rumor circulating online. This is not speculation. This is the law. And if you are not familiar with the rules, you are not simply risking a financial penalty. You are putting your license, your insurance coverage, and your independence on the line. Before we get into all of it, just one thing. This channel covers new legislation, policy shifts, and urgent warnings the moment they emerge, not weeks down the road when you stumble across them buried in a comment thread or hear about them secondhand from a neighbor who got it from someone else entirely. That is exactly why you should subscribe right now and tap the notification bell. It takes no more than 2 seconds. It will not cost you a single thing, and it guarantees you will not miss the next critical update that could affect your rights, your freedom, or your personal safety. Do that now, then come right back. Now let us talk about the federal driver alert system, why 44 million seniors are already inside it, and why you absolutely must verify your name before August draws to a close. The issue this system was created to address is genuinely serious. On one side, you have the freedom and independence of more than 48 million Americans aged 65 and older who currently hold valid driver's licenses. That represents close to 1 in every 5 drivers out on the road. On the other side, you have the natural consequences of aging that can influence a person's ability to drive safely, slower reaction times, reduced night vision, diminished peripheral vision, and cognitive shifts that can cloud judgment behind the wheel. These two realities are on a collision course, and the federal government has stepped in with a system intended to find a balance between public safety and personal freedom. But here is the detail that ought to genuinely concern you. This system does not simply ask you to tick a box and move along. It monitors your medical history. It tracks reports submitted by your physician. It flags your name when specific conditions are diagnosed. And once your name is inside the system, a countdown begins, a countdown that expires on August 31st of this year. If you have not cleared your name by that point, your license is in jeopardy. Not because you did a single thing wrong on the road, not because you caused any kind of incident, but because your name is in the system. And the system is not interested in your driving history. It is only interested in the data it has collected. This does not begin in Washington. It does not begin in some remote federal office building. It begins in exactly the same place yours would. Picture this. You are a 71-year-old retired construction worker. You have been driving since you were 18 years old. Your record is completely clean. You drive out to the hardware store. You drive yourself to your medical appointments, and you drive over to spend time with your grandchildren on weekends. You go in for a routine visit with your doctor. You mention that you have been feeling a bit more forgetful than usual lately. Nothing alarming, just the ordinary forgetfulness that tends to come along with getting older. Your doctor listens, jots something down in your file, and sends you on your way. You think absolutely nothing of it. But what you are completely unaware of is that your doctor, under the law, in certain states, is required to report that notation to the DMV. And what you are also unaware of is that the DMV, upon receiving that report, enters your name into the Federal Driver Alert System. You are not informed of this. You are given no heads up. You simply find a letter in your mailbox one day informing you that your license is under review and that you have until August 31st to clear your name. If you let that deadline pass, your license is suspended, not because you did anything wrong behind the wheel, but because your doctor submitted a report and you never even knew it was taking place. Here is the piece of this situation that should genuinely disturb you. The Federal Driver Alert System is not one single centralized database. It is a network of state-level reporting systems that all feed upward into a national framework. 5 states currently require physicians to report specific medical conditions that may compromise a person's ability to drive safely. Those states are California, Nevada, New Jersey, Oregon, and Pennsylvania. Delaware was previously included on that list, but its mandatory reporting requirement was revised in 2024. In these 5 states, your doctor does not have a choice in the matter. They are legally obligated to report you, and once they do, your name goes directly into the system. But it does not end there. Family members and concerned community members can also file reports in many states. That is correct. Your next-door neighbor, your grown child, or even a stranger who observes you driving cautiously can submit a report to the DMV. And that report can set off a review, and that review can place your name inside the federal system. And once your name is in there, the clock is running. August is the hard deadline, and if you do not take action, your driving privileges are gone. The resolution, the actual legal framework underpinning this system, is now fully active across the United States. Let me translate that into plain, everyday language. The federal government has established a tracking system that monitors senior drivers who may be considered at risk due to medical conditions. This system is supplied by state-level mandatory reporting requirements. In California, Health and Safety Code Section 10,390 requires physicians to report any patient diagnosed with a disorder involving lapses of consciousness, which includes Alzheimer's disease, dementia, and epilepsy. In Pennsylvania, Title 75 PACS, Section 1518B, requires physicians to report any patient aged 15 or older who receives a diagnosis of a condition that could potentially interfere with safe vehicle operation. In Oregon, the mandatory reporting program applies to drivers who have functional or cognitive impairments that could affect their ability to drive. In New Jersey, physicians have a 24-hour reporting window for certain specified conditions. And in Nevada, comparable mandatory reporting laws are currently active. Every single word here carries weight. These are not voluntary or optional reporting guidelines. These are legal obligations, and your physician is required by law to comply. But even if you happen to live outside these 5 states, you are not automatically in the clear. More than 17 states, along with the District of Columbia, restrict online license renewal past a certain age threshold. In Washington, drivers aged 70 and older are required to renew their license in person every single time. In Missouri, the standard renewal period is 6 years, but it drops to 3 years once a driver reaches age 70. In the District of Columbia, drivers who are 70 and older must renew in person and must provide a physician's statement confirming that they are physically and mentally capable of operating a vehicle. This system exists everywhere, and it continues to grow. But do not get comfortable just yet. Here is where the majority of people watching this fall into the exact mistake that transforms a well-meaning safety system into a genuinely dangerous false sense of security. They assume that because they are capable drivers, because their record is spotless, because they have never once been in an accident, they have absolutely nothing to be concerned about. And truthfully, most of them will never run into a problem. But that very assumption is precisely what leaves them blind to the trapdoors built into this system. Those two words, certain conditions, are carrying more weight in this entire framework than anything else. The laws do not define certain conditions with precise, surgical clarity. They leave significant room for interpretation, and that interpretation is exactly where the danger lies. There are 3 specific trapdoors embedded into this system. Know every one of them before you ever find yourself needing that knowledge. Trapdoor number 1, the definition of conditions that may affect driving ability, is expansive and open to professional interpretation. In Pennsylvania, the law mandates reporting of any condition that could impair safe driving. That is an exceptionally broad standard. It does not apply exclusively to dementia or epilepsy. It could encompass arthritis, which can limit your ability to turn the steering wheel. It could include diabetes, which can produce episodes of dangerously low blood sugar. It could cover sleep apnea, which leads to excessive drowsiness during the day. It could apply to any number of conditions that your physician determines, in their professional judgment, could affect your ability to operate a vehicle safely. And the moment your doctor forms that opinion, they are legally required to submit a report. You do not get any input. You do not get to seek a second opinion before the report is filed. You do not get the opportunity to appeal your doctor's judgment beforehand. The report goes to the DMV. Your name enters the system, and the countdown begins. Trapdoor number 2. The DMV does not require a traffic violation to take action against your license. This is the single most critical piece of information that every older driver must fully understand. The DMV holds the authority to suspend, revoke, or place restrictions on your license based entirely on a medical report submitted by your physician. You are not required to have had a single collision. You are not required to have received a single citation. You are not required to have committed a single moving violation. One report from your doctor is sufficient. And once that report lands at the DMV, they are empowered to open a full review. They can require you to submit to a medical evaluation. They can require you to complete a vision exam. They can require you to take a behind-the-wheel road test. And if you fail to meet any one of those requirements, or if you allow a deadline to slip past you, your license is gone. Not because you did anything wrong while driving, but because your physician reported you, and the deadline standing between you and your license is August 31st. Trap door number 3, and this is the one that catches the greatest number of people completely off guard. The reporting process is frequently conducted in confidence, and you may have no awareness whatsoever that it is even taking place. In many states, the identity of the person who submitted the report is legally protected. That means your physician can file a report against you, and you may never learn who made it. You will receive a letter from the DMV informing you that your license is currently under review. But that letter will not identify who submitted the report. It will not specify what condition prompted it. It will simply notify you that you are required to submit to an evaluation or face suspension of your license. And you are left completely in the dark, trying to figure out what happened, trying to determine who filed the report, trying to understand why your driving privileges are suddenly hanging by a thread. That is the trap. That is the vulnerability. That is the exposure that every senior driver faces. Your own physician, the person you trust most with your health and well-being, can file a report against you, and you may never find out it was them. But even with full awareness of all of this, there is one single most dangerous moment that can erase every protection you have built. It is the moment you voluntarily give it all away. You are seated in your doctor's examination room. Your physician poses a question. It sounds like a standard part of the visit. It sounds completely harmless. They ask whether you have experienced any episodes of memory lapse, or they ask whether you have been feeling dizzy or lightheaded at any point, or they ask whether you have had any moments of confusion recently. These questions carry the tone of routine medical screening. They sound like your doctor is simply doing their job thoroughly. But they are not casual questions. They are diagnostic inquiries. And if you respond affirmatively, if you acknowledge any of those symptoms, your physician is legally required to file a report in those 5 states. That is correct. Your own words, spoken inside the confidential space of your doctor's office, can set off a mandatory report to the DMV. And once that report is filed, your name enters the federal system. And once your name is in the system, there is no pulling it back. Do not say yes. Do not acknowledge symptoms that could trigger a mandatory report. Do not hand your physician the information they need to file against you. So what exactly do you say? What specific words will actually protect you in that situation? The answer is absolutely not to be dishonest with your doctor. Being dishonest with your physician is genuinely dangerous. It can result in a misdiagnosis, improper medical treatment, and serious consequences for your health. The answer is to know the law, to understand which specific conditions trigger mandatory reporting requirements in your state, to ask your physician directly whether they are obligated to report your condition to the DMV, and if the answer is yes, to fully understand what that means for your driving privileges going forward. You have the right to that information. You have the right to ask for it. And you have the right to obtain a second medical opinion before any report is ever submitted. But you must be the one to ask. You must take a proactive approach. You must not operate under the assumption that your doctor will bring it up on their own. Many physicians do not. Their primary focus is your medical health, not the administrative requirements of the DMV. They may not even consider the reporting obligation in the moment a diagnosis is made. But the moment that diagnosis is entered into your file, the law requires them to act, and you are the one left managing the fallout. Now let me give you the complete actionable protocol, the full step-by-step process you need to follow in order to protect yourself, your license, and your independence. Step 1, verify your name in the system immediately. Do not wait around. Do not tell yourself you are probably not in it. Reach out to your state DMV and ask directly whether your name has been entered into the Federal Driver Alert System. Ask whether there are any pending reports or active reviews connected to your record. Ask whether there is a response deadline. In many states, that deadline falls on August 31st. If you hold off until after that date has passed, it may already be too late to do anything about it. Take care of this today, right now. Pick up the phone, visit the website. Do not put it off. Step 2, learn the specific reporting requirements in your state. If you reside in California, Nevada, New Jersey, Oregon, or Pennsylvania, your physician is legally required to report certain medical conditions directly to the DMV. Visit your state DMV's official website and locate the mandatory physician reporting laws. Identify which specific conditions require a report. Find out what the reporting timeframe looks like. Understand what process unfolds after a report has been filed. Write all of this down, place it in a dedicated folder, and make sure the people in your family are aware of it. Step 3. Have an open and direct conversation with your doctor. At your next scheduled appointment, ask your physician directly whether they are legally required to report any of your existing medical conditions to the DMV. Ask them which specific conditions would trigger that obligation. Ask them to walk you through what the process looks like after a report is filed. Ask whether they have previously had to report a patient. This is not an act of distrust or confrontation. It is an important conversation between partners in your healthcare. Your doctor should be completely willing to engage with you honestly and openly on this topic. If they are not, that is a signal worth paying attention to. Step 4. If you are diagnosed with a condition that falls under mandatory reporting requirements, do not panic. You still have meaningful options available to you. You can request a referral to a driving rehabilitation specialist. You can enroll in a defensive driving course. You can pursue a second medical opinion. You can work in partnership with your physician to manage your condition effectively and demonstrate that you remain fully capable of driving safely. The objective is not to conceal your condition. The objective is to take control of it and show clearly that you can still operate a vehicle without risk to yourself or anyone else. Step 5. If a letter arrives from the DMV informing you that your license is currently under review, do not set it aside. Do not discard it. Do not convince yourself it must be some kind of error. The DMV issues a firm deadline by which you must respond. In California, you are required to contact the DMV Driver Safety Office within 5 days of receiving the notice, or your license will be automatically suspended. In other states, that window may be 30 days, 45 days, or August 31st. Deadlines in this process are non-negotiable. Do not allow one to slip past you. Respond without delay. Pull together your complete medical records. Obtain a written statement from your physician confirming that you are medically fit to operate a vehicle. Submit every piece of documentation on time. Step 6. If the DMV requires you to undergo a medical evaluation, a vision screening, or a behind-the-wheel driving test, prepare thoroughly beforehand. Do not walk into any of those assessments without proper preparation. Practice your driving skills consistently. Schedule a comprehensive eye examination. Confirm that none of your current medications are producing side effects that could impair your ability to drive. Consider enrolling in a driver refresher course. The more thoroughly you prepare, the stronger your odds of passing every requirement with confidence. Step 7. If the DMV places restrictions on your license, do not surrender. You may have grounds to appeal that decision. You may qualify for a restricted license that permits you to drive during specific hours of the day or within a defined geographic area. A restricted license is not a defeat. It is a workable middle ground. It keeps you mobile, it preserves your independence, and it reduces risk for both yourself and other drivers sharing the road with you. If your state makes this option available, ask about it specifically. Do not allow pride to stand between you and staying on the road. Step 8. If your license is ultimately revoked, you retain the right to formally appeal that outcome. You can file a request for a hearing. You can present current medical documentation. You can bring a physician to speak on your behalf during that hearing. Do not simply accept the decision as final. A significant number of drivers have successfully overturned these outcomes by presenting updated medical evaluations, Documented evidence of safe driving history, or written statements from family members and trusted friends who can speak to their driving capabilities firsthand. You are not without power in this situation. You are not entirely at the mercy of the system. But you must move quickly and decisively. Deadlines matter enormously. Do not let them go by unchallenged. Step 9. Document absolutely everything. Maintain a thorough and organized record of your medical diagnoses, all test results, every piece of correspondence exchanged with the DMV, and any communications that have taken place with your physician. If a report is ever filed against you with the DMV, you will have the documentation necessary to challenge it. If you are ever called upon to complete an evaluation, you will have the documentation ready to demonstrate that you are medically fit to drive. Do not place your trust solely in your memory for any of this. Memory is unreliable over time. Paper endures. Step 10, and this is the final step, the one that continues to protect you long after everything else has been handled. Check your name before August comes to an end. Do not wait until the final week. Do not wait until the very last day. Do not assume that someone else in your life will take care of it for you. August 31st is a firm and unmoving deadline. If your name is currently inside the system and you have not cleared it by that date, your driving privileges are at serious risk. Do not allow that to happen to you. Check today, check again tomorrow. Continue checking until you have complete and absolute confirmation that your name is clear. This is not something that is optional for you to consider. This is preparation. This is protection. This is your freedom and your way of life on the line. This entire effort is not about stripping away your freedom. It is fundamentally about preserving it. The federal driver alert system was not designed as a tool to penalize you. It was built with the intention of keeping you and every other person on the road as safe as possible. But genuine safety demands knowledge, and knowledge demands decisive action. You now have that knowledge in your hands. The only question remaining is what you choose to do with it. Do not delay until it is too late to act. Do not tell yourself that someone else will take care of it on your behalf. Do not convince yourself that these rules apply to everyone else, but not to you. They apply to you. They apply to 44 million senior drivers spread across every corner of this country. And if you fail to act, you are not simply gambling with a financial penalty. You are gambling with your license, your insurance coverage, and your hard-earned independence. That is the unvarnished truth. That is the warning being delivered to you today. And that is precisely why you must take action right now. Verify your name, review your state's specific requirements, confirm the deadline, and make sure all of it is done before August runs out. Your freedom depends entirely on it. Your personal safety depends on it. And the safety of every other person sharing the road with you depends on it. This is not optional. This is preparation. This is protection. This is your responsibility.